to reassure scientists of the fact that when they actually put in their very best, they're recognized and their work is also protected. Thank you.
Honourable members, it's now the turn of Honourable Katie.
Thank you, Chair. Honorable Dr. Zareto Ajiman-Rales, congratulations. I really don't know where to start, but I believe you know what I mean. We thank the President for giving you this opportunity and a much bigger platform. You're already on a big platform, but you are now, if approved, will be on a much bigger platform to continue to demonstrate your intellect, your competence, and what we know, as I say, can-do attitude and getting things done. God bless you. Thank you.
Thank you very much. Honourable members, in the absence of the minority leader, I will proceed to discharge the nominee. You are accordingly discharged. You hear from the committee.
Thank you, Honourable Chair.
I will then proceed to acknowledge your guests. We have Honourable Huese. Two, we have Honourable Jim Tamaklo, who is also my uncle as well as your uncle. We have Lovelace. We have Benjamin Nikwe Kote. We have Auntie Frimpoma. We have Kimati Ajiman Rollins. We have Madam Judy Nkansa. We have Nana Poku Ajiman. We have Mr. Ato Gezi. We have Auntie Amaki. We have Mr. Kenneth Wugan. We have Shelley Chikata. We have Shiba Atiesa. We have Alex Kojo Atiesa. We have Colonel Agbotui. We have Squadron Leader Sinsin Dagbe, retired. We have Naval Lieutenant KK Anyawe, retired. We have Dr. Mavis Ureku Ahinkra. We have James Gunu, Voter Regional Minister. We have Mr. Robbie Robertson. We have Cromwell Goka. We have Nana Kobe Prempre. We have Maoli Alomanu. We have Salim El Mawas. We have Charles Bain. We also have Alahaji Masaud, John Blagoji, Lydia Agbotui, Gosson Agbotui, Juliet Kramer, General Kusi, Dr. Kumbo, Hajia Hamdatu Ibrahim, Eshen Elliot. We have Dr. Ben Anyagri. We have Regina Aholu. We have Kwame Boachi Ajiman. We have Mark Dabre Mafo. We have Dr. Mr. Krujison. We have Walter Ewua. We also have Nana Jensi Amwako. We have Sisi Kwenu. We also have Alberta Achia Akosa. We have Bevlo Latte. We have Akresi Sapon. We have Yao Ampofo Ankra. We have Alasan Soini. We have Queen Mothers from Ashanti and Volta region. Honourable members, on your behalf and on behalf, we have Mayor of Tema, and then the spouse of the majority, Chief Whip. We have Dr. Kobena Dufour. We also have former chairman, Dr. Ampofo. On behalf of the committee and on behalf of the House, I welcome all of you to Parliament of Ghana. You are accordingly discharged. Thank you for attending upon the committee.
What time are you going to start?
We are starting now.
We're starting now. Oh, yeah. The first one is first
Yes, it's Asante.
I don't know how long that will
It depends. Our distinguished guests kindly take leave of us to give us the opportunity to take the next nominee. Our distinguished guests kindly take leave of us. Honorable Zaneto Rollins, please, you can do this outside so that you give us the opportunity to take the next nominee. Please kindly take leave of us for us to proceed with the work.
Mr. Speaker, I salute. Yes, sir. And I salute the minority leadership also.
Yes, sir.
Madam.
The small chief of staff was enjoying a Pan-African family. I've taken it away. So, you know, my working changed at the Pan-African, and now I'm going to be a...
You will be an ordinary member. Our next nominee, kindly take your seat. This pen is for you.
Mine. them that they should leave for us to take another nominee. Why is they leaving the room?
May I humbly ask honorable members and our distinguished guests to take their seats. Distinguished guests, kindly take your seats. Clerk of Parliament, you may please proceed to administer the oath.
Please, we will.
I, Justice Edward Amuakon Asante,
Swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee,
that the evidence I shall give before this committee,
touching the matter in issue,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Honorable nominee, thank you very much. Thank you very much for, or congratulations, and thank you for appearing before the committee. Minority Leader indicated he has a preliminary issue. May I give him the floor?
Chairman, we, the minority, have a preliminary objection to the vetting of 3 Supreme Court nominees today. Our objection, which I would here put across, are as follows. That, Chairman, today this committee takes a single further step towards the vetting of 3 nominees of appointment as Supreme Court justices. The minority would want to put on record a formal preliminary objection to the manner and timetable within which the vetting is proposed to be conducted. This is not an objection to the principle of vetting. It is an objection to the nominee, neither is it an objection to the nominees as individuals. It is an objection grounded in the Constitution, the 1992 Constitution, and the standing orders of Parliament, to a process that, as currently proposed, cannot lawfully and safely be completed within 3 days remaining in this recalled sitting. We ask that this objection be resolved before this committee to proceed further, and that it appear on the record of these proceedings, regardless of how it is resolved. We advance 9 grounds. Each stands independently. Together, they are in our respectful submission conclusive. 1, ground 1, that there is no vacancy and therefore no exigency capable of justifying a compressed timetable. Chairman, the Supreme Court of Ghana presently sits with its full complement of justices. No seat on the bench is vacant. The 3 persons before this committee are nominated to add to the existing membership of the court, not to fill any gap left by death, retirement, or removal. This matters because the entire justification
offered for compressing the ordinary vetting timetable is urgency. Urgency requires an urgent state of affairs. Where no vacancy exists, no functional agency exists. The committee is respectfully urged to require the majority to identify precisely and on record what harm befalls the state, the judiciary, or any litigant if these 3 additional appointments are vetted with the same care that would ordinarily attend any Supreme Court nomination. We submit that no such harm can be shown because none exists. Ground 2, Order 21711 has been misapplied. But even so, Chairman, before I go into Ground 2, we submit that since 1992, all Supreme Court nominees have gone through the regular period of notice where this committee advertises in the dailies for 2 weeks. It cannot be, and it must not be, that just Monday when Mr. Speaker announced the nomination as received from the President, Tuesday, Wednesday, and Thursday, Parliament is supposed to vet. It is not our position that we are against any of nominees. Neither are we saying that the President doesn't have the constitutional mandate to nominate for Supreme Court. What we are saying is that your party in opposition, and I refer to the verbatim reports of 2024, July. Mr. Speaker, Mr. Chairman, the transcript of appointment committee proceedings, 30th July 2024, and I use this transcript to support my ground 2. This is what was said by Honorable Mahama Ayariga, Member of Parliament for Boku Central, then in opposition. Quote, "We discussed this matter and said we don't want to embarrass these judges. It's a new appointment committee. Notice was served to the nominees to come without us having had a meeting. No meeting. Notice was served to the public to submit memos, and there was no meeting. Then yesterday we met, we said, quote, what is the rush? End quote. We have a lot of time. So let's take our time and not embarrass these judges. Let's do a decent job. We ask for documents. We ask for the writings and publications of one of the nominees. Then the other, who is the Court of Appeal judge, we ask for her judgment. You know how we always do it, so that we can study and do a decent job. And they wanted to even fix a date. Then the majority chief whip advised the 2 leaders to go and confer on the date. Chair, end quote. He goes further. We had these discussions nicely, and then we all dispersed yesterday, only to see during midnight WhatsApp exchanges that we were being someone as a committee to come and vet this book. Because of that, some didn't even go through their CVs. Now let me go to Honorable Ama Kofi-Boa, who was a deputy minority leader and a member of the committee. This is what he had to say. Quote, I was saying that first of all, why do we have a media here? The point has been made that the appointment committee met. We discussed these matters. We all agree that these appointments are important. These are lifetime appointments. And once they sit in the Supreme Court, there's no opportunity for any Ghanaian to try to revoke the appointment. These nominees are going to replace Supreme Court judges that are not going on retirement, some of them till November. So it was clear that we have time to make sure that as our standing practice of this House, we published this nomination by the President in National Daily and get memoranda from the public so that we can totally, the people of Ghana must be part of this process. It's a serious process. We all agreed. I mean, let the point be made. Nobody has anything against, but we must do the right thing. End quote. This is Honorable Ama Kofi Bua, Deputy Minority Leader, who is now a Minister of State. Now let me go to my respected colleague, who is now the Finance Minister. He was the Minority Leader, Dr. Kasiel Ato Forsen. This is what he had to say as Minority Leader then. Quote, "Then let me make this comment. Honorable Leader," he was referring to the chair who is seated to my left, Honorable Patricia PJ. She was the Deputy Majority Leader and the acting chair of the committee. Yesterday, I said something, and today I'll refer to you as my former friend because I'm honestly appalled. This is Atu speaking. I'm appalled. You have broken the trust of the NDC Minority Caucus. You have committed a number of sins. I will tell you the sins that you have committed. Your first sin, you unilaterally wrote a letter to the nominees inviting them for vetting without the input of the appointment committee. That's their first sin. Sin number 2, all your sins. Your sin number 2, you wrote to the nominees certain Wednesday 31st after informing them that we are Wednesday 31st without our input. Then number 3, after we met as committee, your third sin, after we met as committee and agreed that we'll do this vetting before we are recalled, so that during the recall, we will take them, you will take them unilaterally again and again. No, I'm enumerating all the sins that she has committed. And then you inform them that now you have shifted the goalpost from 31st. Then we even agreed to Tuesday, and going forward, you hold it and submit the report to the House. Madam, this is not Banana Republic. All these are words coming from Ato Forsen. This is the Republic of Ghana. This is the Black Star of Africa. This is Kwame Nkrumah's Republic of Ghana. Please don't destroy our democracy. This is coming from the NDC. At the minimum, you have to give us the opportunity to study the nominees, and the people of Ghana must see us that we are doing our work. We cannot joke with this democracy. These are some of the things that we do, and the democracy elsewhere, they lose them. We will protect this democracy at all costs. You are putting somebody into constitutional office until the age of 70. All what we are asking is that advertise for a minimum of 14 days. Invite memoranda. So far, you have advertised for 4 days. Even the advert, you didn't tell us you were advertising for this. Advertise for 14 days. Give us opportunity to review the CVs. Today, you have called a meeting. Me, today, I have not even read anything. I will end it here. Chairman, to reiterate ground 2 of our submission, these are the words of your party in opposition. You insisted that Supreme Court nominees should at least have that 14 days minimum notice in the dailies. You told us that back in the day, on that fateful day, what you did was to stop the vetting. We are not going to be physical. We are going to be decent and put across our case to the nation. My colleague here who was chairing the committee was heckled. We reasoned with you. I was the majority leader. And I called Dr. Ato Forsen aside, pleaded with him. Much as I tried, he said no. And on behalf of the government, I yielded to the prayer of the minority. So we called off the vetting. We apologized to the nominees. And we re-advertised for the 14 days before we finally did the vetting. So what has changed? You are saying that we must protect the democracy. We yielded to you because common sense required that we had to listen to you and not to insist that we are in government. We stopped. You said there must be 14 days. These were the words of the minority leader, speaking for and on behalf of the NDC. These nominations came to the House on Monday. Referral was made to the committee on Monday. We are Tuesday. We had yesterday. And today we are to do vetting. We have Supreme Court judges and the respected Chief Justice right here. In all fairness, would they themselves feel right that Parliament is subjecting itself to these? Are we here to embarrass the nominees or carry a certain conduct and back with a political narrative? My colleagues in majority, no. Let's reason together. Let's be seen as having a principled political stand. Let's be seen as acting consistent with our political views. We yielded to you. We didn't allow ego to take over our conscience. So we yielded and asked the nominees to go back home. And at the right time, after advert, we did it. So if you want to follow that precedent, please suspend today's sitting. And let's properly put out the advert as you requested back then when you were in opposition. And let's allow 14 days. After all, the court is on vacation. 14 days, we can come back and do the work, receive memoranda, get our report ready even before Parliament resumes in October. Early enough for before the new legal year. We cannot continue to do this. I'm done with ground 2. Now let me go to ground 3. Ground 3. Order 21711 has been misapplied. It is our contention that Order 21711 requires this committee to report to Parliament within 3 days after the conclusion of its proceedings. That is a clock triggered by conclusion, a fact within the committee's own determination, not a clock that runs from the date of the referral or that compels conclusion by any particular date. No provision of the standing orders convert Order 21711 into a general instruction that vetting itself must be completed within 3 days or within the life of any particular sitting. Order 2674, by contrast, allows a committee up to 3 months to report on a matter referred to it. We submit, therefore, as minority, that Order 21711 cannot, on any proper construction, be read to shorten that general period to 3 days for 3 simultaneous Supreme Court nominations. Our next ground, that the composition safeguards in Order 2172 and 3 cannot be honored on this timetable. Chairman, we submit that Order 2172 requires the chairperson, ranking member, and 2 other members of the relevant subject matter committee to join this committee for each nominee considered. For the 3 judicial nominees, that is the committee responsible for constitutional, legal, and parliamentary affairs. For the 2 ministerial nominees, it is, in each case, the relevant sector committee. Order 2173 caps the resulting membership at 15. We therefore submit that properly reconstituting this committee 3 separate times for 3 distinct subject areas whilst respecting the 15-member ceiling and the 1/3 quorum requirement in Order 2651 cannot be done with the rigor these orders contemplate inside 3 days without either breaching the cap, diluting the co-opted membership actual participation, or reducing what should be substantive scrutiny to a formality. Any of those 3 outcomes will render the resulting recommendation procedurally unsound. We further submit that the public participation safeguard in Order 21710 would be rendered nugatory or odious by your conduct of proceeding to vet these nominees today. And on that point, it's our submission that Order 21710 requires the publication of nominees' names in the newspapers of national circulation for the specific purpose of inviting memoranda and representation from the public. Chairman, I rely on Dr. Atuforson's verbatim submission of 30th July to support this submission without reiterating that point. It is the mechanism by which citizens, the bar, and civil society bring to this committee's attention anything material to a nominee's fitness for judicial office that this committee itself might not otherwise know. A publication made this week, followed by hearings this week, gives no realistic person outside this chamber an opportunity to research, prepare, and submit memoranda before this committee purport to conclude. We therefore submit that a safeguard, which as a matter of simple arithmetic cannot be used, is not a safeguard that has been complied with. It has been observed in form and defeat in substance. We argue further on a ground to the effect that no motion to suspend the standing orders has been moved. Chairman, on the floor, there was no such motion properly moved, argued, and resolved to the effect that any of our standing orders be suspended. What we know is that the majority, after we were done with business committee report meeting, claimed to have recalled the business committee to hold another meeting, whereupon they claim that they added the vetting of Supreme Court nominees this week, and that after the majority leader has presented his report, same was gavelled as having been adopted. Chair, never on the House floor have we had such a precedent where a business committee's report was used to override express provisions of our standing orders. The adoption of a business committee report and recommendation can never replace an express provision of our standing orders that require a motion to be properly moved. Chair, we further submit that it is only by motion, moved with the leave of the House, with reasons stated prior to suspension. No such motion has been moved in respect of orders 2172, 3, 10, or 11, or of orders 265, 266, or 2674 in connection with these three nominees. Every one of those orders therefore remain in full force today. We submit with respect that the committee or majority within it cannot achieve by mere scheduling what order 3 requires to be achieved by motion, debate, or vote. To proceed as though these orders had been suspended without the House ever having suspended them is not an exercise of discretion. It is a disregard of rules that remain binding. We invite you, Mr. Chairman, to ensure that this committee is bound by Order 217 in its unamended and unsuspended form, and to conduct these proceedings accordingly. Our next ground, that the constitutional preconditions to nominations under Article 1442 have not been shown to be satisfied. Chairman, we submit that Article 1442 of the Constitution makes the President power to nominate an ordinary justice of the Supreme Court conditional upon the advice of the Judicial Council and consultation with the Council of State. These are not procedural niceties. They are conditions precedent to a valid nomination reaching this committee at all. We submit, therefore, that before this committee proceeds to question any of the three nominees on merit, it should require the Clerk of Parliament or the Attorney General to confirm on record that the advice of the Judicial Council was in fact obtained and that genuine consultation with the Council of State in fact took place in respect of each of the three nominations. A truncated timetable makes it materially harder for this committee to verify that these upstream constitutional conditions were actually met, rather than merely asserted. This committee ought not to vet nominees whose own constitutional foundation has not first been confirmed. Our next ground, we submit that this exercise of discretion by the majority required to compress this timetable offends Article 296 of the Constitution. Chairman, Article 296 provides that wherever discretionary power is vested in any person or authority, that power carries an implied duty to be fair and candid, and its exercise must not be arbitrary, capricious, but must accord with due process of law. The chairperson's power under Order 2663 to fix the date and hour for considering a referred matter and the business committee's scheduling of this committee's business generally are both discretionary powers within the meaning of that article. We submit, therefore, that a timetable driven solely by the desire of the majority to conclude before this record rises tomorrow, unsupported by any demonstrated exigency, given that no vacancy exists, is not an exercise of fair and candid discretion. It is discretion exercise to suit convenience, political convenience, and it is, on that basis, vulnerable to challenge as arbitrary within the meaning of Article 296 of the Constitution. Our ground 8. Mrs. Chairman, the Speaker's own ruling on the nature of this recall fortifies our objection. And on this point, we submit that in his remarks opening this recall, the Right Honorable Speaker drew a distinction of direct relevance to this committee. He stated in terms that his determination to recall Parliament was not and must not be understood as a determination of merit of the matters placed before the House. He stated that the material before him at that stage was not conclusive and does not dictate what Parliament must decide. He stated that the responsibility to weigh these matters properly belong to the House itself. We submit, therefore, that this committee, exercising the House's delegated function under Order 217, is bound by precisely the same discipline the Speaker described. The admission of these nominees for consideration during this recall settles nothing about whether they are fit to be approved, still less about how quickly that question may responsibly be answered. A committee that treats the fact of the recall as itself an answer to the question of adequate scrutiny will be doing exactly what the Speaker cautioned this House against. And I must emphasize that this unfortunate situation is being advanced by the NDC majority. Now, our ground 9. The consequence of error here is uniquely severe and largely irreversible. Chairman, I submit on behalf of my colleagues that Article 146 of the Constitution protects a sitting judge from removal, save for stated misbehavior, incompetence, or infirmity, established only through an elaborate multi-stage process. Once appointed and sworn, a justice of the Supreme Court is for practical purposes in office for the remainder of a working career. Parliament's approval under Article 1442 is realistically the last substantive check this republic will ever exercise over that individual's fitness for judicial office. We therefore submit that a procedural shortcut which might be tolerable for an appointment more easily corrected is not tolerable here. The gravity and near permanence of office being filled is itself a reason, independent of every ground above, why this committee should decline to allow itself to be rushed. The majority must not use its super majority in terms of numbers to stampede this process. Democracy requires that they sit and reason with us and not muzzle its weight and powers and frustrate the views of the minority. Chair, for the above grounds as argued, these are the reliefs we seek from this honorable committee. The minority, led by me, pray this committee for the following. 1, rule that, Mr. Chairman, determine that Orders 2172, 3, 10, and 11, as well as 265, 266, and 267 4, remain in full force. No motion to suspend any of them having been moved or carried under Order 3. 2, we further pray that this committee resolve to decline to conclude its consideration of the 3 Supreme Court nominations within the life of this recall sitting, and instead adjourn that consideration to allow proper compliance with Order 2172 and 10 of our rules. 3, we pray that require confirmation on the record from the Clerk to Parliament or the Attorney General that the preconditions in Article 1442 of the Constitution have been satisfied in respect of each nomination. 4, is our prayer that this committee resolve to proceed in the meantime an unfair and expedited timetable with the vetting of the 2 nominees, which we have done, on which no objection of any kind was ever raised by us, because there is precedence of the House to support that. And finally, record this objection and the committee's final determination in the report of the committee, ultimately as it presents to the House under Order 215. Chairman, with all said, I conclude on behalf of my caucus that this our objection is not being raised to obstruct the work of this committee. Neither is same being raised to embarrass any of the nominees before us. As we have already said, they are men and a lady who have worked all their life in service of our nation and even the sub-region. The president has the power and mandate to nominate them. We are not opposed to that nomination, save that when it was Akufo-Addo's time and he brought 3 Supreme Court nominees, your side argued that it amounted to the packing of the courts. So as we speak today, you have nominated 7, Parliament has passed them, and these 3 added to it make it 10. So what has changed? Where is your principle? Now, the numbers to the Supreme Court are far more than it would have been if Akufo-Addo's 3 additional nominees had been approved by Parliament. So where is your principle of the packing of the court? Where is your principle? You have none. We so submit. A committee that vests a justice of the Supreme Court in 3 days, in the absence of any actual vacancy, in the face of standing orders that remain fully in force, and were never suspended, does not strengthen Parliament's constitutional role. Rather, it empties that role of its content. We ask that this objection be decided in our favor. The proceedings should not go further, and whatever the course this committee takes must know that it has gravity to Order Article 144, Article 146, and Article 296 of the Constitution, as well as Order 217 of our own standing orders. The people of Ghana demand it. This is not a partisan demand because we are MPP minority. This is a demand from the people of Ghana. This is a demand that democracy requires of us. And Chair, we submit respectfully that this committee be resolved, that all these concerns be taken into consideration. We suspend the hearing and do the advert and come back and do the vetting. Until then, we tell you that, Chair, don't use your numbers to stampede this sound submission. Thank you very much.
Honorable members, our distinguished guests, I have sat and listened carefully to the objection raised by the minority leader. And it gives me much interest as how a lecture in metaphysics will give to a newborn baby. I said so because, honorable members, following a request by His Excellency, the President of the Republic of Ghana, to recall Parliament to deal with specific items, a request that was contained in a letter emanating from the President dated 11th August 2026. 3 items were the basis of the President's request for a recall of Parliament. 1, the Banks and Special Deposit Taking Institution Act Amendment Bill 2026. 2, 2 nominations for appointment as Ministers of State for referral to the Appointment Committee, vetting, and consideration by Parliament. 3, 3 nominations for appointment as Justices of the Supreme Court for referral to the Appointment Committee, vetting, and consideration by the House. So clearly, the request was not only limited to the referral of the nomination of 2 ministerial nominees, vetting, and consideration by Parliament. It includes the referral of the 3 judges nominees, referral, and vetting by the committee. Based on this request, Parliament was duly recalled to sit from Monday 24th to Friday 28th of August 2026. Honourable members, distinguished guests, accordingly, these referrals were made. And again, the referrals were not limited to that of the 2 ministerial nominees. It extends and operates to include the 3 judges nominees. Following the referral, there was a meeting held yesterday. The meeting was consequent upon the chairperson of the committee having a preliminary meeting with the minority leader to consider the request of His Excellency, the President. We suppose to have the vetting on Wednesday, but it will interest you to know that at the instance of the minority leader, today, Thursday, 9 o'clock has been scheduled to conduct the vetting. We had a preliminary meeting yesterday, dealt with certain issues and concluded them. For me, that was the end. What was the issue raised and considered? I will go straight to the one that is relevant to the objection raised by the minority leader and how we dealt with the issue. The issue was to the effect that we should only consider our colleague ministerial nominees, 2 of them, but we should not consider the 3 judges. Based on the fact that there was no publication, and therefore we should not proceed to do the vetting of the judges. The committee resolved that the referral includes the 3 judges nominees. We cannot therefore discriminate in favor of our colleague nominees and against the 3 judges' nominees. Therefore, we must take decision to vet all of them together. This was the decision of the committee. The further reason of the committee was to the effect that on Monday, when the business statement was presented, part of the business statement requested from the House to use Standing Order 3 to suspend the Order 217 of our standing orders in order to pave the way for us to deal with the urgent items based on which the request for recall was made, and the House was accordingly recalled. I have in my hand the provisional Hansard of Parliament of Ghana. I'm not tendering it, but to quote the relevant portion. Honourable members, Roxanne Nelson Kwame Eche Dapamako, the majority chief whip, raised the issue that upon the presentation of the business report, he wants to formally move a motion for the House to adopt, to waive the Standing Order 217 so that we can urgently consider the request of the President. Now, the Right Honorable Speaker, Alban Sumana Kingsford Bagby, was the one presiding. And this is what he said. Once the request for waiver based on Standing Order 3 of the House was part of the Business Committee's report presented to the House, and the House having adopted the report of the Business Committee, there is no need acceding to the request of the majority chief whip to move a motion to waive the Standing Order 3. Once the House has adopted the Business Committee's report, it means that the House has taken a decision to waive Standing Order 3 for the committee to consider these matters as a matter of urgency. Honourable members, when the committee takes decision, we present report to Parliament, and at the adoption of the decision of Parliament, Parliament at plenary has a right to vary the decision of the committee. However, if the House takes decision, no committee can vary the decision of the House. If you are aggrieved by the decision of the House, the method available for you to reverse that decision is contained in our own standing orders. Honourable members, distinguished guests, I will not preside over this committee and purport to vary the orders or directions or decisions taken at the plenary by the entire House. It is not done in any democracy, and I will not be the first to introduce it in Ghana's democracy. Honourable members, I will not also preside over this particular committee and discriminate against the judges. Allow the vetting of our colleagues and then reject the vetting of the judge's nominee. I will not do that today. I won't do that tomorrow. I therefore consider all grounds of the minority leader as flimsy and hollow. I considered his objection to be frivolous, vexatious, unmeritorious, baseless on the facts, the rules, and the law. Therefore, I will accordingly dismiss the objection by the minority leader in limine. Thank you for your rapt attention.
Chairman, with the greatest respect to you, you don't have the power to dismiss a preliminary objection properly raised. You have responded to me. I have a right of reply, and then we put it to a vote. It's a decision. It is the House, the committee that must resolve. That is how we take decisions. Chairman, if we are talking law, let's talk law. It is not within your right to say you have ruled. You don't rule on issues that come. You don't have the power. There is no such power in our standing orders. Even as a speaker, when a motion comes before the House, he relies on the decision of the House. It is not a matter for a ruling that you will say that you've dismissed with all those adjectives. I won't go there. Let me remind you on some important issues in reply to your response to me. Issue 1. The House did not pass any resolution.
Honorable Minority Leader, with
You've
all
started?
with all due respect, when you are making your submission,
I kept
you
quiet.
called on me.
I didn't call on. I said the resolve.
Rule
no,
on the
I
matter.
didn't say rule. I said resolve. Don't get me wrong. No, resolve.
Honorable Minority Leader,
no, please.
let your microphone be off.
No, Chairman, don't start your thing. Don't start it and then finish and think you can control narrative. We are being very decent. Don't try it.
Minority Leader,
Don't start it, Chairman.
You did not move a motion before the committee. You
Chairman,
raised a preliminary
you can't
objection.
Rule. It's not a ruling.
And the preliminary
a
objection
decision.
is supposed
This
to be
committee
ruled upon by the rules of the House.
No, which rule? Quote it. Quote which rule? Quote the rule. Quote it. If the standing order is here.
Yeah, so
mine is here.
take your
no,
standing
majority
order.
that take your time.
No, take your
majority that he's capable.
No, take your.
He doesn't need a lawyer.
Please.
Let him. Let him. This is it. Rule it. Open.
Take your
Open.
standing orders.
You people are taking this majority thing too far.
Open to 268.
You guys are taking this majority thing too far. No, we've not finished the argument. He cannot. Stop it.
Patrick.
You've had power. One day you may not have the power.
268.
Don't do this.
No, 268.
You know, it's not fair.
Open it. 268.
Majority leader,
no,
stay out of this matter. Stay out of this matter. Which ruling?
Open to 268.
It is not within his right to rule anything here.
Please.
What is he going to rule?
Open to 268.
I moved. You didn't see. Yes. A motion. No. A motion was moved, registering our preliminary objection. A motion was moved. We had a meeting with the clerk and him in his office. You were there. We all agreed that the nominee for the Supreme Court should be done in October. Clerk, he was there. We all agreed that let's do the nominees. So what changed? What changed? Why are you always frustrating everybody? Why are you taking the majority too far? And when we talk, we become victims. Why?
Please.
Why?
Please,
he can't rule.
Please. Okay.
We have to argue. It's a motion that we raised and stated our grounds.
Listen to others.
The preliminary objection was grounded on our motion. Don't do it.
You listen.
He did.
You listen.
You were my mate.
You listen.
You were my mate. I was called before you. I was called before you.
Chairman.
You were my steady mate. And you know my law is unsoiled. So stop what you are doing.
It's very clear. Have you seen the order?
You know my law is unsoiled. You know, Eche. You know. Don't let politics, make you behave this way. I've raised. He cannot rule. He can't rule. Rule on what? It's a motion. He should tell me where he can rule. We have to take a decision and vote.
That person, please.
It's not fair. We have a right of reply. Let us reply. He shouldn't rush. Why are we doing this to ourselves? Why are we doing this to ourselves? It's not fair. Your own position in 2024, Ayerga, you were there. You said 14 days. Why 3 days?
Honorable
Why?
Minority Leader.
And when we react, you start shouting and threatening us.
Honorable.
And you start to threaten us. What's going on in this country? What is going on in this country? Under a reset. What's going on in this country? In today, Ghana, you can't talk. You can't talk. They will threaten you, frustrate you. That's what you are doing. That is what you are doing. Maintain your own principle. Maintain your own principle. You act out of political convenience. Where is your principle? Ayerga is here. He said 14 days on the 30th of July, 2024. What has changed? Honorable Ayerga.
Let me explain what has changed.
Honorable members, I don't know whether my brother, the Minority Leader, has listened to himself. You never said you are moving a motion, but you said you are raising a preliminary objection. And all ears have heard you. So when you raise a preliminary objection, your preliminary objection must be ruled upon. That is different from you moving a motion for the House to take decision on the motion. So based on the fact that what I have heard and what everybody, member of the committee, have heard clearly is a preliminary objection being raised on the grounds, which grounds are therefore considered frivolous, vexatious, unmeritorious,
If you got it wrong,
hollow.
I'm straightening it.
Hollow.
I'm sitting right here that you can't do.
So I have done my ruling, and that is a ruling, and then we'll proceed to vet my lord,
Chairman,
the
please. Chairman, if you I'm
judge nominee.
Chairman, if you construed that to mean, if you construed that to mean an objection which you are going to rule, I am sitting right before you. If you cannot say that the horses are bolted, there's an empty stable. Stop it. This is democracy. Don't do what you are doing. I just got up for a second. They were calling me. You deliberately discharged Senator. I kept quiet. I knew the traps you were setting. I knew what you were trying to do. Let's not do this ourselves. We are not helping democracy. If you construed our objection and the motion to be nothing like that, please, I'm right here. You can rule. Let us debate it. Let's vote.
So let's debate it.
Yes.
So allow me to debate it.
Sure, I'm happy that you will
put
debate.
it off. I want to debate it.
Let's debate. He can't say he's ruling.
Yes.
You don't have the power to rule. Let's
Yes.
take it, and
So-
then you use
yes.
your
So
majority
let's
to
debate
vote
it. Yes.
against us. We'll be satisfied.
listen
So
carefully.
don't do what you're doing.
Yeah, please.
Honorable
Chairman,
members,
permit
with
me.
all due respect, after the ruling by the chair, there will not be any debate that will be open. Honorable members, let us not make the attempt to create a scene when there is none, or there should be none. In my language, it is said that if your farm is not long, you need not go to the farm with a big water can. Decision has been taken, and we shall proceed to conduct the vetting. So, honourable members,
Chairman, please, you've made your point. Can I
I have heard you.
Yes, can
I've
I?
given you
Yes,
every opportunity.
Yes, but can I make a point? Yes, can I make a point? This is a two-sided house. I'm your equal opposite number. Can I also have my bite?
Well, I'm considering what you are doing to be an attempt to delay and derail the committee from doing its work. So we are proceeding to vet the
Chairman.
nominee before us.
Chairman,
Clerk of the committee,
Chairman,
I'll call upon you
The clerk, you know the rules.
accordingly.
That you, the clerks, know that in all
Administer
situations,
oath.
the committee is not a one-sided committee. The clerks, we don't want you to get into this matter. There has to be some consensus here. Don't rush to get into this matter. And we expect the clerk to Parliament to know his job.
Hereby
No clerk
directed
should know.
to
You cannot,
administer
that we have a say.
oath.
The minority
go
must be
ahead
heard.
and
What the majority is doing is wrong. Public servant, don't get into this. It is not your duty. It is not your duty. You, parliamentary service, it is not your, what you are doing is wrong. When we were in power, you never allowed this. Parliamentary service, don't do what you are doing. You are not a partisan institution. You are supposed to be neutral. The ranking is here. Don't do what you're doing. Don't do what you're doing. Don't do what you're doing. Parliamentary service staff, don't do what you're doing. We must be heard. It's not fair. It's not fair. It's not fair. You are taking things too far. Listen and let's cooperate. What you are doing is not fair. Cooperate and let's do the right thing. Let's do the right thing.
Honorable Afenyo, please, Chairman, I beg you. I beg you. Please. Oh, please. I beg, please. Afenyo, I beg you. You see, we are all acting pursuant to the standing orders. Indeed, during the deliberations, I was the one who instructed him to ask Speaker whether or not we needed to move a motion pursuant to Order 3, I think? Yes. For the suspension of the standing orders so that the waiver applies to all the nominees. And Speaker said clearly that he didn't think it was necessary to move a motion to suspend the relevant standing orders because the recall specifically indicates what the recall is for. And he, as Speaker, had given us clear instruction what he wanted us to do. And in any case, what we wanted to do had been captured in the business statement, which had been adopted by the House. On the basis of that, I asked him not to move the motion because Speaker had said it was unnecessary. You cannot come today and fault us on the basis of not moving the motion. You are questioning our professional capabilities. We did not move the motion because Speaker said it was unnecessary and that this recall is to consider the nominations, and because the recall is only for 5 days, we should have all the advertisements, you know, all those requirements waived, applied to everybody. I think that even for you as a minority leader, it will not be fair that you say that in the case of myself and Honorable Zaneto, because we are your colleagues in the House, you are willing to pat us on the back by, you know, waiving, and yet when it comes to the judges, you will not accept it. On what basis are you discriminating between us and the judges? If that's the case, I hand over back to you your approval so that we wait, and the same day that you are considering the judges, I will join them to be considered. That's what I will do, because it's not fair. We should treat each other fairly. Whether a member of a coordinated branch of government, the judiciary, or the executive, we need to treat everybody fairly. So I disagree with you. Secondly, on the authority of the chairperson of the committee, the chairperson is guided by the standing orders. And it says in order 268, general functions of a chairperson of a committee. He sits here as chairperson of the appointments committee, not as first deputy speaker. And it says that 2683, the chairperson of a committee shall maintain order at a meeting of the committee and decide on each question of order. You have raised an issue of order 3. Yes. No, order. No. To decide a question of order. A question of order is when somebody raises an objection on the basis of the order. Is that okay? That is what we mean when we say a question of order. But the first part of order relates to you being, rowdy, disorderly. So it says that the chairperson of a committee shall maintain order. So the maintenance of order relates to making sure that we all conduct ourselves properly before the committee, such as you cannot be speaking when the chairman has not given authorization to speak. That is disorderly conduct. Now, the second issue of order, the second issue of order is procedural questions raised based on our standing orders. So if anybody says, oh, you are violating our standing order, the chairperson is the person who is supposed to rule on it. So the chairperson is right in saying that this is not a matter for debate. You raise an objection, I give you the opportunity, you argue your case, I've listened to you, and I am ruling. And so he is perfectly within his authority, understanding order 2683, to do this. So, my brother, this morning I said you are a nice man, you are a man of integrity. Just 30 minutes ago, you want me to withdraw my statements? We are pleading with you. These judges, if we treat them that way, we will not be fair. Honestly speaking, we will not be fair. Because it will look like we are self-serving as a parliament. We are willing to waive the rules for ourselves and our colleagues, and then not wait for them. We are willing to waive the rules for people who have been nominated to go and serve the president. But we are not willing to waive the rules so that people who are nominated to go and work with the Chief Justice, he too gets his people on time to work with. I don't think that is fair. That's discrimination. And for me, if you insist, I'll give you back your vetting this morning. And then, wait till the day that you are willing to vet them, then I'll join them to be vetted.
Honorable Minority Leader, you are pulling your microphone. I will give you just 5 minutes. It's now 1:48. Exactly 5 minutes. I will stop you.
Chairman, that's not the way to treat your ranking. That's not the way to treat your ranking. Honorable colleagues in the majority, we are only asking you to respect your own principles. Your principles in 2024 and nothing more. This argument of discrimination that you have discovered is again serving your convenience. I told the majority leader that he has a principle called jurikashi. When he's in trouble, he used takashi and somersault it into jurisprudence. So I call it jurikashi. What you just did is jurikashi. You and I know that there is no set power given to the chair to make a ruling. You know it. Now you say there are some general powers. I kept quiet, please. 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 You are not a member of this committee, so please become and let your seniors engage on an important matter. I have not mentioned a name. Please. Who in particular? No, but my colleagues are also there. Yes, but they shouldn't do that. Chairman, what is happening is unfair, it is improper, it lacks principle. All we want to say is that if you insist, because you are the majority, that we don't need any notice, the very things that you said when you were in opposition, they are no more relevant, and that under reset, you have set in place a new rule, which should be the new president. We are sorry. We cannot be part of it. And to the nominees, with greatest deference to you, we respect you, and we are not opposed to your nomination, but the process by me through which the majority is deciding to use is not known to the parliamentary jurisprudence that we all know. So, Chair, thank you very much.
Most grateful. Today, if you need water to wash your hand, I have a bottle of water for you. All right, members, we are proceeding. Clerk of the committee, kindly proceed to administer the oath.
Please put it.
His is on. That's all there. I know left them. I, Justice Edward Amoakon Asante,
Swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee,
that the evidence I shall give before this committee,
touching the matter in issue,
shall be the truth,
the whole truth, and nothing but the truth. So help me.
So help me God.
Thank you very much for administering the oath and the nominee for taking the oath. We'll go straight to vet, and before doing so, let me establish that we have a quorum to commence this business, and we also have a quorum to take decision at the end of the day. So Article 102 and 104, respectively, has been satisfied by the committee. Honorable nominee, proceed to give us a brief background of yourself.
Thank you, Chair. Called Justice Edward Amoakon Asante, born on the 1st of December, 1963, in Afenyo, also where I come from. I'm married with 5 children. I started my education in Afenyo, also primary school, then Odan Secondary School, Afenyo Secondary School, Fanspim School, then Legon. I graduated in 1989 and proceeded to the law school. For my BL, I completed the law school in 1991. I started practice with National Service Legal Aid Board, and then practiced for about 11 years. In 2002, I joined the bench as a circuit court judge. I was posted to Obuasi. I worked there for 5 years and got elevated to the High Court in 2008. Where I've been in High Court, I was posted to the Fast Track High Court in Accra. After 5 years, that was in 2013, I was transferred to Sekondi in the Western region as the supervising High Court judge. And after 5 years in 2018, I got appointed to the ECOWAS Court of Justice, where I worked. This is my 8th year, and the tenure has just ended. And I was the president of the court for 6 years. So now I am back. In 2020, I was recalled and elevated to the Court of Appeal as part of the elevation process because I was due to be promoted. Basically, this is a short resume of myself. Thank you.
Thank you very much. We shall proceed to ask you questions. I will then give the floor to Honorable Elikplim Akurugu to start asking you questions. Please be brief in your answers.
Thank you, Mr. Chair. Congratulations.
Thank you.
I did a background on you, and I found it very interesting because you have an extensive regional and international judicial experience. I want to ask a question quickly. Given your extensive experience, both in Ghana's judiciary and as a president of the ECOWAS Court, what safeguards should exist to ensure that a judge who is being considered for elevation or appointment remains completely independent of those involved in appointment process?
Thank you very much. Basically, as a judge, when you are appointed, you swear an oath, which you go by. That is a very important thing, that you do fair, you be fair and equitable to all manner of persons who appear before you. Judges decide cases by facts before them. You apply the law to the facts and all that. Judges do not go mingling with the appointing authority just because they appointed you. Independence of mind is very important, and that is why I've gone to where I've gotten to. Independence of mind in the ECOWAS Court, as you know, we deal with presidents, heads of states who we meet, but therefore, and still when matters come before us, we'll deal with them as they are based on the facts, and therefore I think I have the independence of mind to be able to withstand all kinds of influences, if any, to do my job. Thank you very much.
Any further question?
Yes, I have a follow-up. So, would you recuse yourself from a case involving a person who had played a significant role in your own elevation if circumstances created a reasonable perception of conflict?
I don't know what you mean by a person. So, I don't know what you mean by a person who has played a role in my elevation. I know that I'm a judge of the Court of Appeal, and I qualify to be at the Supreme Court. I'm 35 years old as a lawyer. I've worked as a judge for over 20 years, and therefore I qualify by the Constitution. The Judicial Service has given its advice, Judicial Council its advice. Council of State have been consulted, and now I am here pending your approval. And therefore, that is all I know. I do not see whoever got involved in anything. The President knows, of course, in consultation, on the advice of the Judicial Council, knows I qualify. That's why I've been appointed. And therefore, I don't know who did that. In any case, if that is it, it's so clear. Talking about biases, maybe that's what you are talking about. It is clear that when the matter involves an individual whom you think you know very well, as a judge, if your conscience doesn't serve you well, you just recuse from it. But if it's a company that a person is involved, or a general matter like on Article 2.1 and all that coming to the Supreme Court, if you give me the nod to have interpretation and all that done, and the person is even a person that I know, I have to deal with it because that's the calling of the job I'm doing. Thank you very much.
That will all be, Chairman.
Thank you very much, Honorable Elikplim Akurugu. I will then move to Honorable Beat Zidi. And I affectionately call him Azidi.
Thank you very much, Honorable Chairman. And let me use the opportunity to congratulate you for your elevation from the Court of Appeal to the Supreme Court. Indeed, I've gone through your CV, and it is quite a rich CV. You have risen through the ranks from the High Court to the Court of Appeal, and then to now going to the Supreme Court. I have a few questions for you, probably one or two. The first one is, Article 22 of the Constitution enjoins Parliament to enact legislation to regulate spousal property rights. My Lord, what has been the evolution of spousal property rights in the jurisprudence of Ghana to date?
This question is very convoluted, but I will, however, allow my Lord to answer the question.
Thank you very much, Honorable Chair. It actually has a checkered history. Back in the days, excuse me to say, women and children were considered as chattel of the man. And therefore, when the man and his wife and children did whatever property, upon his death, it went to the man's family and not to the wife and children. They even lived in the house subject to good behavior. As time went on around the early 60s, luckily for us, the case of Corte and Mate surfaced. And the court, in that particular case, that's what they said. But then subsequently, I think Abebrese and Carr, the court said that if the wife especially did substantial contribution towards the property, then you'll be given a part of the property. That's how it started. Then it has been on, so the court relied on contribution, substantial contribution and all that, until recently, though Parliament was given the authority by the Constitution to make laws on spousal property. Unfortunately, Parliament reneged, sadly to say. And the Supreme Court, in its activism, judicial activism, took it up in the cases of Arthur and Arthur, Mensah and Mensah, Quatson and Quatson, and subsequent ones that have come and have ruled that it should be on equitable basis. And therefore, currently, that's what we are applying. So each one can own his or her own property and can also earn joint property. That it should be contribution and all that. So it's equitable. So property acquired in the course of marriage is still based on contribution and the equitable share of the property. Thank you very much.
Further question?
Honorable Chairman, there will not be supplementary question, but I have a second substantive question.
Please go ahead.
My Lord, as I said, I went through your CV, and I've seen that you have experience and expertise in humanitarian law as well as international law. My Lord, what is the difference between the two? In other words, international law and humanitarian law, is there any difference between the two? And if there is, what are the differences? Thank you, my Lord.
Yes, Honorable Nominee.
Thank you very much. There's a world of difference between them. International IHL, international humanitarian law, we call it the law of war. It's basically laws that are made affecting victims and wartime. So it could be the victims of war, soldiers, prisoners of war, people injured in course of war, destruction of war. So there are particular laws, set of laws, refugees and migration. That's international humanitarian law. So basically, the Red Cross and Red Crescent and those institutions are in support. So that is the international humanitarian law. So laws are meaning the kind of weapons to use in particular kinds of war, what to attack and not what to attack. You cannot just go and attack hospitals just because you are fighting a battle between for governance and all that. Schools and where people, civilians are. Exactly what's happening, unfortunately happening in Iran and those places. So that is, so it involves armed conflict. It can be internal armed conflict or international armed conflict. Then international human rights law is law as it affects individuals. No, you ask about international law. It's law as it affects international institutions or states, like the NGOs and UN agencies and states themselves. So that's the law that governs them. Mostly it's by treaty law, either bilateral treaties or multilateral treaties. That is international law, basically. So that's the difference between international humanitarian law and international law. Thank you very much.
Any further question?
No further questions.
Thank you very much. Yes. It's now the turn of Honorable Haji Aladi.
Thank you, Chairman. Because I'm not a lawyer, I do not know or have those words that they readily use. But as a P1 teacher, I will say congratulations and say that I wish you all the best in your endeavors. I met you first at ECOWAS, and I have listened to you with all the lectures and what have you. So I want you to just tell me or tell this committee 3 achievements of yours at ECOWAS Parliament or when you were the chairman of the ECOWAS court. Thank you.
Yes, Honorable Nominee.
Thank you very much. As the president, in fact, from the initial stages, I was made president of the court, and I've been we are 2, the longest serving presidents for 6 years, myself and the very first president, who was a Nigerian lady. When I entered the court, there was a lot of staff backlog, promotions backlog, over 50 or 60 of them. We had to make sure we did interviews and all that and because it brings stagnation and then frustration among the staff. So that staff issues were the first thing I did, and we promoted all of them to their levels. We made sure we recruited very efficient people. So now the research department of the ECOWAS court is one of the best in West Africa, in Africa actually. So judges don't find it difficult at all in writing the judgment because we are very good people to do the judgments for us. Then during the COVID, I had to improvise and do online hearing. Make sure we bought all the super highway IT equipment and all that we needed. And therefore, I can tell you that since COVID time, nobody travels to Abuja anymore to have their matter heard. You just do your documentation, you scan and email them to the court. When the court receives them, you also look at it. If it conforms to the rules, it is scanned and emailed to the other side. And then hearing is done online. So somebody in Senegal who has sued somebody in Niger, there's a serious, very good internet facility and everything in the court. So we just sit in the court, hear the matters, and deliver judgment without people buying tickets for themselves and for their lawyers to travel as it used to be. And therefore, we have saved the citizens lots and lots of money. Then, to add on to it, the final one is the electronic case management system, which was recently launched, though not during my tenure, but I started it. It is to the effect that now it's paperless. So you just file your processes, it goes to the court, they look at it, automatic stamping or filing on it, then it is also transmitted to the other side. So it's purely paperless. The president also just clicks a button and selects the panel. So all these things were done under my might. And then the judgments, when we went, we saw that the work rate was very low. And for the first time, we did 48 judgments in a year. That's about 2020. Then the following year, we did 68 judgments, which is record in the court, has never been done. So these are some of the achievements that I did there. Thank you.
Any further question?
Thank you, Chairman. Yes. Although the response to my next question might emanate from the one that you just responded, I would wish that you state it clearly for us all to know that at least there is a way forward, bringing you to the highest level in this country. And so I would want to find out from you if you would consider suggesting and following up so that AI can be infused into our court system in Ghana.
Honorable Nominee.
Thank you very much. AI is the way to go now. Now the world has gone AI. There's nothing anybody can do. We have had a little bit of training in the ECOWAS court, the judges and even the staff. And wherever we went, it is there. So basically, if the Chief Justice seeks my inclusion for it to be done, why not? Because at least I have some knowledge in it. It's a matter of trying to get people to do our own special setup for us. Even you, Parliament, you can do it. You have your own setup. The algorithm is built for you. So it's a tailor-made thing for you. And once it is done, for us, the judicial service, it will have to be included. The lawyers will also have to be using it. So it's a big whole system that can be done easily. And once it is done, it's going to bring efficiency into our system. So cases will be dealt with fast. Research and all that can be done on it. So hallucinations will be dealt with in the system. Once it is tailor-made, it is tailor-made for us. They know how to build the algorithm and all that to capture our system. So I don't think it's too much of a problem, except that it's all finances, as we say. So finance, once you are the ones who approve the budget for the judiciary, if you consider approving higher amounts for them, it can be done easily. Thank you very much.
You have any more questions?
No, please, Chairman. I wish you all the best.
Thank you very much. I will then give the floor to Honorable Mahama Shaibu.
My Lord, congratulations. And two quick ones, my Lord. Given the complex and enormous cases that we have now in our justice system, I'm sure the Chief Justice sitting behind you, he knows that you have to do even afternoon sittings of courts. Would you rather we separate judicial work from administrative work so that Chief Justice concentrates on the judicial stuff and then the administration is rather manned by somebody else? Thank you.
Yes, Honorable Nominee.
Thank you very much, Honorable Chair. For me, that shouldn't be the case because the Chief Justice is the head of the judiciary, as the president head of the state and then the executive, as the speaker is the head. So his duties cannot be divided. For me, for instance, maybe it gets to the area of empaneling of judges and all that. That is his duty, administrative work, and therefore he should be able to do it. People talk about giving it to machine and all that, which I do not subscribe to. Especially, for instance, as I'm talking about humanitarian law, human rights law, international law and all that, if there's a matter and the computer selects and doesn't include me, he will be, I mean, the decision may not be too rich. I'm not saying I'm too much there, but then at least that is an area I've gotten enough of experience. The other people have experience in other areas. They should be empaneled to do the work and enrich the jurisprudence of the court. So I don't think they should be decoupled. He should have both duties as the head of the judiciary. Thank you.
A further question?
Yes, a further question. My Lord, the famous case of Tufo versus AG in the political cycles of Ghana, we've played it around like a football. Where it pleases us, we play it positively. Can you explain how important this is or what role it has added to our jurisprudence?
Thank you very much. For an Attorney General, it's a very important case so far as particularly the constitutional jurisprudence of Ghana is concerned. You know, prior to that, there were issues with supremacy, but it clearly affirmed what we now have, constitutional supremacy. It said that whatever the Constitution said is what is final and not parliamentary supremacy. Though there were powers given to the parliament, but it said that whatever the Constitution has said, that the Chief Justice, prior to the coming into Constitution of the 1969 Constitution, was CJ, should be the CJ, and that was upheld by them. It also enforced the rule of law clearly. It also enforced the fact that citizens could come to the court not as person injured, but to vindicate rights that generally affect the entire nation. Because those Tufo who went to court was not the one affected at all. But they gave him the right, he had the standing to sue, they admitted it and did all that. So rule of law was enhanced, supremacy of the Constitution was enhanced, and all those things. So that is basically how it enforced the constitutional jurisprudence of Ghana. Thank you.
Any more questions?
My Lord, just a final one. Two very important chapters in our Constitution, that's 5 and 6, fundamental human rights and freedoms, and directive principles of state policy. How related are these? And is there any distinction that you can clarify regarding these? Thank you.
Yes.
Thank you very much. We know that Chapter 5 on basic human rights, it emanates from the UN and all other human rights treaties that Ghana has acceded to. Then we brought in the directive principles of state policy, which are basically economic, social rights. So the difference is that for us, Chapter 5 is on human rights that affect individuals, their rights, basically inviolability, right to dignity, right to life, the right to be informed when you are arrested and all that. Those are rights that affect the individual personally. But the social rights, as in the Chapter 6, are general societal rights. And those rights, the SIBA case has said that they are not enforceable until maybe some of them are also found in other parts of the Constitution. So that's basically the difference. Whereas these ones are enforceable, Chapter 5 are enforceable, Chapter 6 are not enforceable, except that if parts are found elsewhere. And it is clearly understandable because these ones involve finance.
Chairman, thank you very much. My Lord, you are welcome and congratulations. I practiced before you, and I know how formidable you are. So I have no doubt that you continue to distinguish yourself when you get to the upper bench. My Lord, my question is very simple. Let me situate it within the remit provided for in Article 21(1)(e), freedom of association. What is your position regarding professionals of any shade and hue, including lawyers, forming associations? Associations, that's all. Freedom of association.
Yes, Honorable Nominee.
Thank you very much. Yes, the Constitution guarantees various types of... Thank you very much. I've been alerted that there's a matter before the Supreme Court regarding that. And therefore, you know, unfortunately, I've been out of the jurisdiction for all this while, so I'm not aware. So I'm sorry. If I make a pronouncement on it, and the CJ, if you approve me, and the CJ empanels me, I will be found wanting to have. So please, forgive me.
Chairman, let it slide. No, hold on. It's about freedom of association as enshrined in the Constitution. I am not saying that say any other thing. I'm just asking you, what is your position of freedom of association? That's all.
Yes, Honorable Roxanne Nelson Kwame Eche Dapamokbo. There was an earlier decision regarding this in the case of Ward Brew versus Ghana Bar Association. Yes. But the indication is that there is a fresh matter before the Supreme Court, and my Lord does not want to comment on the matter sub judice. So therefore, I will humbly overrule the question and will not ask my Lord to answer. So you may ask another question.
Thank you very much. Now, my Lord, let me ask you this. Is any portion of the Constitution justiciable, especially in terms of Article Chapter 5, rights in the Constitution? Justiciable, any portion of that?
Thank you very much. Yes, Chapter 5, you are talking about the human rights. Yes, right to bail and all that. I have always had the notion why suspects have not sued the police for keeping them for times on end after the 48 hours. These are things that people should be doing for us to know that the courts are able to confirm what is in the Constitution for those things to happen. So all those rights, for me, are justiciable. Yes, thank you.
So as a follow-up, will you be inclined to agree that it is time there are statutory, Parliament takes steps to enact a law on bail, to define the parameters of bail, like a bail act? Especially because bail appears to be, the right to bail appears to be justiciable, but it continues to create some controversy when the courts exercise that discretion time and time again. So do you agree with some who are calling on Parliament to come up with a bail act to guide the court regarding the circumstances to grant bail, set out in an enactment? A couple of other jurisdictions have done that.
Yes, my lord.
I do not think that is necessary in our circumstances. Act 30 is a clear act. It is there. Then, to reinforce, there's Martin Pebu, an Attorney General. That said, all the matters are bailable. And therefore, it is there. It is people who, or lawyers who have not sued those who have detained their people beyond the time on behalf of their clients. That's exactly what I espoused earlier. So if you take action and the court declares and finds, award against those who have done so, then it will be fine, so that everybody knows that you cannot just get people, keep them, and all that. So that's what I can say to that.
Chairman, that'll be all. Malone, once again, congratulations.
It's now the turn of Honorable Kweku Ricket Hagan, alias Kokube.
Thank you very much, my lord, and congratulations. I want to take you said some interesting things when you were talking about technology, especially with AI. I just want to find out from you, your view, since you have done some work in that area. There is one school of thought that believes generally that in the legal world or the legal practice, AI is to help with routine work, legal work that is quite routine, such as research, contract review, and what have you. But there is also another school of thought that it is not just to augment the legal work, but it could one day replace human lawyers. I just want to know your view on that, whether you believe that that will happen one day. I don't want to frighten my colleagues lawyers here, but your view on that, as you believe strongly that technology or AI is the way to go in future legal practice as well. Thank you.
Yes, Honorable Nominee.
Thank you very much. AI cannot replace lawyers or judges. The human thinking is unique. Despite all the things that it does the research for you, and you have to go through and make sure that it has done what you want. You have to query it. To get the best out of it, you have to query it several times before you get even what you want. And therefore, its thinking capacity does not get closer to anywhere the human brain can think to. It can help you, support you. You put in, you feed it, it brings out something, you feed it again, you query it, then it will be removing and adding until it gets to what you want. Even then, you still have to read and approve. So if you are a lawyer and you allow, that's why some lawyers in Canada and other places just did Googled or they went to AI, took stuff and filed it as if they were cases and all that, and they were cut out. So for you to get it, you have to work on it. That's why I'm saying it should be tailor-made for particular institutions. If that is done, they fed in all your, for instance, in our case, all our cases, all our laws are fed into it. The algorithm because it's machine training. Once you train it, it can give you the best out of what you want. So for me, AI cannot replace lawyers or judges. But some lawyers may want it to replace them. If they are lazy, they don't want to think, that may be an issue. Thank you very much.
Further question?
Thank you, Chairman. I have no further questions than to wish the nominee well. Thank you.
Chair, if I may say, I missed you at Infanspim. You left in 83, I came in 83, 83, 84. So when I came, you had left.
So clearly, he's 2 years your senior.
Let me just correct Honorable. I was at Adisada College, and you were in France. I knew you.
You, yeah, exactly.
Yeah.
We knew ourselves.
Well, when Infansipim and Adisada College, they are talking, a man from Abode Secondary School should not speak.
We also talk. Abode school.
I am a proud Aboscan. People don't know where it is, but I'm really proud of that school. My Lord, it's now my turn to ask you questions. But I have appeared before you severally in my private practice as a lawyer. I know your integrity. I can vouch for your competence, the professionalism, and I intend not to ask you any question. I will then use the opportunity to crave the indulgence of my colleagues to announce and acknowledge the presence of your distinguished invitees who are here to support you. We have Bismarck Bedu, is a business executive. We also have Mr. Charles Adokwe, is also a business executive. We have Mrs. Gifty Asante, the spouse of the nominee. We have Mr. Brian Kojo Asante, son. We have Miss Akosua Asantiwa Ankama, daughter. We also have Dr. Kwasi Safo Boachi, is a pharmacist. And we have Brigadier General Richard Akoto, is a military officer. We have Dr. Samuel Oredu Yebua, is a medical officer. We have Mr. Henry Asante Donko, brother. We have Mr. William Esua, brother. We have lawyer Kwesi Blay, brother. Miss Yoni Kulendi is also there. All other justices Justice Kumson, all other justices are duly acknowledged. The former bar president, everybody, you are welcome. Honorable nominee, you hear from the committee, and accordingly, you are discharged.
Thank you very much, Honorable Chair and members of the committee. Thank you.
You will surely hear from us. But we are doing the fiscal council members. We are doing the fiscal council members because it has worked.